specification in 817, it would be F5, theft of a credit card. As I said, in case number 22 CR 817, there would be no agreed recommendation as to sentencing, but at the time of sentencing or after sentencing, the state would move to dismiss count 2 in case number 22 CR 816. Thank you.
All right, Ms. Brooke.
Thank you, Your Honor. I have had opportunity to review the plea offer with Ms. Martin, and she is in a position today to accept the offer and enter in the change of plea before this court.
All right, Ms. Martin, how old are you?
57.
You can stay seated.
Thank you, Your Honor. I'm sorry.
How far did you go through school?
11th grade.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
All right, in case 22-816, did you get a copy of the indictment?
Yes.
And my understanding is you're going to plead guilty to count 1, possession of cocaine, a felony 5,
Yes.
and the forfeiture specification, and then count 2 would be dismissed at the time of sentencing. Is that your understanding?
Yes.
And in 22-817, you're going to plead guilty to theft, a felony of the 5th degree. Is that your understanding also?
Yes.
All right, now before I accept your guilty plea in each of these cases, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question or you want more time to talk to Ms. Bruick, let me know and I'll give you more time. Do you understand that?
Okay, yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
And if you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today on these two cases, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No.
Do you still want to plead guilty on both these cases?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
Do you understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes.
In 22-816, possession of cocaine is a felony of the 5th degree. It carries a maximum prison sentence of 12 months and a maximum fine of $2,500. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're voluntarily giving up all items listed in that specification. Do you understand that?
Yes.
In 22-817, theft is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 24 months and a maximum fine of $5,000. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand your conviction in 22-816 may result in a driver's license suspension of between 6 months and 5 years?
Yes.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed on either of these cases, you might have to serve a period of post-release control as part of your sentence
Yes.
for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If your violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 24 months. Do you understand that?
Yes.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Ms. Brewick before pleading guilty today?
Yes.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Mr. Hurd, in 22-816, if that case went to trial, what would the evidence show?
If the matter went to trial in 22 CR 816, the state would prove beyond a reasonable doubt that on January 22nd, 2021, the defendant, Martha Martin, in the city of Wickliffe, Lake County, Ohio, was picked up on a felony warrant in the parking lot of the Fairbridge Hotel. In her right jacket pocket was a bundle of suspected drugs. Those drugs were seized and sent to Lake County Crime Lab, where they tested positive for cocaine, a Schedule II drug of abuse, and weighed at 0.06 grams. Thank you.
All right, Ms. Brewick, anything to add to those facts?
No, Your Honor, thank you.
Ms. Martin, did you hear what Mr. Hurd said the facts would show if that case went to trial?
Yes.
And are those facts true?
Yes.
All right, and then what is your plea to possession of cocaine, a felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
All right, Mr. Hurd, if 22-817 went to trial, what would the evidence show?
Thank you, Your Honor. If 22 CR 817 went to trial, the state would prove beyond a reasonable doubt that the defendant on November 19th, 2021, in the city of Wickliffe, Lake County, Ohio, at the Quality Inn Hotel, was again picked up for an active warrant. The police were initially dispatched there for a missing wallet. The defendant was seen on surveillance video going into a stairwell where the victim, Sally Kincaid spelled Kincaid, dropped her wallet and stated to police officers where she dropped it. The defendant was later found with the wallet, and it contained 2 credit cards inside of it belonging to the victim. Thank you.
All right, Ms. Brewick, anything to add to those facts?
No, Your Honor, thank you.
All right, Ms. Martin, did you hear what Mr. Hurd said the facts would show if that case went to trial?
Yes.
And are those facts true?
Yes.
All right, what is your plea to theft, a felony of the 5th degree?
Guilty.
All right, Ms. Brewick?
Thank you, Your Honor. Permission to approach? Thank you. Thank you, Your Honor. For purposes of the record, Ms. Martin has affixed her initials and indicated that she is a citizen of the United States were indicated on the change of plea document.
Right here.
And then today's date is 12/3. That's okay. And, same on this page. Second case. Thank you, Your Honor. May it please the court, for purposes of the record, in case number 22 CR 817, Ms. Martin has affixed her signature to the written plea of guilty and put today's date, and counsel has signed as witness to her signature. Furthermore, in case number 22 CR 816, Ms. Martin has affixed her signature and today's date on the written plea of guilty, and counsel likewise has affixed her signature and witnessed Ms. Martin's signature.
Thank you. I witnessed the defendant as well as their counsel sign the written pleas of guilty in both case numbers 22 CR 817 as well as case number 22 CR 816, and I'm going to return those both to the court shortly.
All right. Ms. Martin, on both of these documents, is this your signature on the written pleas of guilty?
Yes, Your Honor.
And did you sign both of them voluntarily?
Yes.
And do you want me to accept your written pleas of guilty?
Yes.
All right, I will accept both written pleas of guilty. Defendant was present when Ms. Bruick advised of all of her rights, made a knowing, intelligent, voluntary waiver of those rights. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept her plea of guilty and find her guilty in 22-816 of count 1, possession of cocaine, a felony 5, and the specification, and in 22-817, guilty of theft, a felony of the 5th degree. I refer both cases for a pre-sentence report, a drug and alcohol evaluation, 817 for a victim impact statement. Sentencing will be January 15 at 2:30, and the bond is continued. Anything else, Mr. Hurd?
No, thank you, Your Honor.
Ms. Bruick?
No, thank you, Your Honor.
All right, we're adjourned.
All right.